Hello everyone! Ang tagal na ng topic na to. Sana matapos na rin natin today ang Article 1480 to Article 1488 talaga. Samahan niyo ako ulit. Article 1480. This provision speaks about who bears the risk of loss. Okay? The rule is, if yung object was lost before perfection, the seller bears the loss. Obvious naman, di ba? Wala pa namang contract. Bakit si buyer? So, si seller talaga. Kasi before perfection pa nga. Now, second is, if the object was lost after delivery to the buyer. Dito naman, malinaw. Malamang si buyer na, okay? It is the buyer who bear the loss. Kasi, na-deliver na nga sa kanya. Ang sabi nga natin sa previous video lectures natin, okay? Delivery, transfer, ownership. So, nung na-deliver yung object kay buyer, yung owner na nito is si buyer. And then, naalala niyo pa? Res perit domino. The owner bears the loss. Okay? But then, I want to bring your attention sa third scenario. That is, kasi ito yung sinasabi ni first paragraph ng Article 1480 talaga. Okay? If yung object is lost after perfection ng contract, but before delivery ng object or determinate thing. Okay? During that intervening period. Perfected na yung contract pero hindi pa na i-deliver ni seller yung object kay buyer. Ang question, who bears the loss? Okay? Take note. Dito, the buyer bears the loss. This is an exception sa rule na res perit domino. Owner bears the loss. Kasi dito, before perfection. I mean, before delivery. Okay? Before delivery, so, meaning hindi pa na-transfer yung ownership, it is still the seller, yung owner ng object, kasi wala pang delivery. But then, during that intervening period, sabi ni Article 1480, si vendee or si buyer ang magbe-bear ng loss. Kasi daw, during that intervening period din naman, it is the buyer who gets the benefits if ever meron. Okay? Hence, it is just fair that he must also shoulder the loss. Pero meron din naman tong exception, okay? So, ano-ano ba ang exception sa rule na si buyer ang magbe-bear ng loss between that intervening period, between if ever nagkaroon ng loss ng object during that after perfection but before delivery na period? Okay? Ano yung exception? Siyempre, una na dito yung last paragraph ni Article 1480 itself, okay? Yun daw mga fungible things sold for a price fixed according to weight. So, yung mga 100 pesos per kilo, okay? Or according to number. Like, example is yung 100 pesos per 10 pieces, ganon. Or according to measure. So, 100 pesos per meter. Yung mga ganyang things. Ang sabi, this shall not be imputed to the vendee until they have been weighed, counted, or measured and delivered. So, until such time na yung mga fungible things na ganyan, okay, yung mga object or fungible things na wini-weigh, kina-count, or mini-measure, okay, ay hindi pa na i-deliver, hindi pa na-weigh, na-measure, or naka-counted at wala pang delivery, then it is still the seller who bears the loss. Okay? Fungible things, okay, na binibenta for a price fixed according to weight, number, or measure. Okay? Unless, yung last phrase, okay? Yung last phrase is, huwag kalimutan, the buyer has incurred in delay. So, meaning, if the buyer is in mora accipiende, then, siya na rin yung magbe-bear ng loss. Another exception, if yung seller is guilty of fraud, negligence, default, or violation of contractual term. Pag ganon, hindi si buyer ang dapat mag-bear ng loss. May malamang naman, kasi nga guilty si seller, di ba? So, siya yung mag-bear ng loss. Another exception pa. If yung object sold is a generic thing, syempre naman din. No need to explain further. Sana nga naalala nyo pa yung genus does not perish. Genome non quam perit. Okay? Anyway, to better understand this provision, Article 1480, let's take an example. First scenario. Today, Pogi sold to Ganda his Mitsubishi Expander car for 1 million peso. Pero hindi alam ng dalawa na nasunog na pala ang car kahapon. Okay? Does Ganda has to pay Pogi? Ito yung tanong. Ang sagot, no, hindi. Because the car was destroyed before perfection, right? Kahapon pa pala, wala na yung car ni Pogi. Such that, nung time ng perfection ng contract nila ni Pogi and Ganda, which is today, there was no more subject matter. Nasunog na kahapon. It was already destroyed. Okay? So, ang sabi ko kanina, res perit domino. The owner bears the risk. So, that is easy. First scenario. Second scenario, madali rin naman to. Eto, today, Pogi sold to Ganda his Mitsubishi Expander car for 1 million pesos pa rin. And then tomorrow, say, kinabukasan kaagad, dineliver na ni Pogi kay Ganda ang kanyang Mitsubishi Expander car. And it was agreed na yung payment would be at the end of this month. Pero, if bago pa man natapos ang buwan na to, before the end of this month, the car was destroyed. Say, nasunog nga, okay? Thus, Ganda has to pay Pogi. The answer is yes. Upon delivery ng car sa kanya, there was already transfer of ownership, di ba? So, si Ganda na ang owner ng car at the time it was destroyed. And, ang sabi ko kanina, res perit domino, the owner bears the risk or the loss. And so, si Ganda ang magbe-bear ng loss. She needs to pay the amount of 1 million peso to Pogi, okay? Now, eto na tayo. The third scenario. The exception to the rule or kung ano ba yung pinovide ni Article 1480. Okay, today, Pogi sold to Ganda his Mitsubishi Expander car for 1 million pesos. Ganun pa rin. I-deliver niya sana tomorrow. Payment would be by the end of this month. Okay? Pero, if bago pa man dumating si tomorrow, okay, bago pa kinabukasan, meaning to say, kinagabihan ngayon, the car was negligently destroyed. It was set on fire ng isang stranger named Beauty, without default of Pogi. Okay? Question. Does Ganda has to pay Pogi? And thus, Pogi still have to deliver the car. Answer? Pogi is excused from delivery kasi it was destroyed without his fault. But Ganda has to pay Pogi the 1 million pesos. Kasi, although hindi pa siya ang owner ng car, she must bear the loss in the same way as she would have been the one to profit. Okay? Kung yung sasakyan, instead of being destroyed, it has increased in value, di ba si Ganda rin naman ang magbe-benefit? Now, if nagkaroon ng loss, then siya rin yung magbe-bear ng loss. Okay? But, Ganda has the right to proceed against the person, kung sino man ang at fault sa pagka-destroy ng sasakyan. Ganda can dito, okay? Dito sa example, Ganda can proceed against Beauty the negligent stranger, and she can ask for damages under the rule on subrogation. Okay? So, if the car was lost and destroyed due to the fault of Pogi, so eto ibang story nito. Dapat it should be Pogi who would then bear the loss. Okay? Malinaw ba? Hopefully nga, na-gets nyo. Kasi, first provision pa lang yan. We still have Article 1481 to 88. So, punta na tayo kay Article 1481 para makapag-move on. So, eto. Article 1481. In the contract of sale of goods by description or by sample, the contract may be rescinded if the bulk of the goods delivered do not correspond with the description or the sample. And if the contract be by sample as well as description, it is not sufficient that the bulk of goods correspond with the sample if they do not also correspond with the description. The buyer shall have a reasonable opportunity of comparing the bulk with the description or the sample. So that's Article 1481. Sale by sample or sale by description. Pag sinabi mong sale by description, si seller sells the things and si buyer is relying only sa description ng thing according kay buyer. When you say sale by sample naman, only sample is exhibited or shown. Yung bulk of goods is not present as to walang opportunity si buyer to examine the bulk. The seller only warrants that the bulk of the goods shall correspond with the sample. Okay? Meron ding sale by sample and description or by description and sample. Dito, dapat yung dalawang requirements ay present. Yung sale by sample and description. Hindi pwedeng either lang. Anyway, to better understand Article 1481, let's again take another example. If si Pogi agrees to buy from Ganda 100 sacks of rice by sample, and so dineliver na ngayon ni Ganda to Pogi ang 100 sacks ng rice. But then, nung inexamine na ni Pogi yung mga bigas, he finds out that it was not equal to the sample na binigay ni Ganda. And so, nagreklamo ngayon si Pogi to Ganda. Question, ano ba yung mabuting gawin ni Pogi? Well, he may return the sacks of rice to Ganda. Basta dapat naman he have not retained them for so long. Diba? Dapat reasonable period of time or yun nga, reasonable period or time lang din for purposes of examination. Okay? Kasi if after ma-find out ni Pogi na yung quality ng rice was not the same as the sample, pero ginamit niya pa rin yung isang sako ng bigas. And yung ibang sako ng bigas, binenta niya. Okay? Pag ganyan, he can no longer repudiate the contract and recover the price kay Ganda. Okay? That's unfair, di ba? I mean, yung right ni Pogi is to claim compensation na lang from Ganda for the breach of warranty if ever. Pag ganun yung ginawa niya. Okay? Anyway, let's take another example. Si Pogi, binenta niya kay Ganda ang kanyang refrigerator by description, okay, for 10,000 pesos. Now, although yung description was completely correct, meaning as described, yun naman talaga. But then, yung refrigerator does not, hindi siya nag-work properly for which it has been purchased. And so, si Ganda refused to pay the balance of the purchase price. Kaya, question, is Ganda, kailangan bang magbayad ni Ganda? Answer, since this is a sale by description, and the description is correct, di ba? Sabi, this description was completely correct as described. So, the buyer therefore must pay the price because the object delivered tallied with the description naman. Okay? So, yun yung sale by by description. Now, wag na nating patagalin. Let's proceed with Article 1482. Whenever earnest money is given in a contract of sale, it shall be considered as part of the price and as proof of the perfection of the contract. Okay, so earnest money na tayo. Earnest money is actually part of the purchase price. It is also a proof of the perfection ng contract. So, example, if si Pogi sell his car to Ganda for 1 million pesos, payable within 1 month, and so to show Ganda's earnestness, nagbigay na siya kagad ng 100,000 to Pogi upon the perfection ng kanilang kontrata. So, etong 100,000 pesos is the earnest money. And at the end of the 1-month period, si Ganda ay kailangan na lang magbayad ng 900,000 pesos. Kasi yung earnest money na naunang binayad ni Ganda kay Pogi, no 100,000 pesos is part na ng purchase price. So, idididak ngayon yun sa balance ni Ganda. Okay? Let's differentiate it from the option money or option contract. So, dito kay earnest money, si earnest money applies in a perfected sale. And so, yung earnest money again is part ng purchase price. Kaya si buyer is required only to pay for the balance. On the other hand, kay option money, wala pang perfected contract of sale. And so, hindi talaga siya magpo-form part sa purchase price unlike kay earnest money. Kung tutusin nga, the money is given as a distinct consideration for the option contract. And so, the would-be buyer is hindi rin required to buy. And the option money may even be forfeited. Diba? So that's how option money and earnest money is different from each other. Ganun sila, iba sila. Kaya, i-master nyo na rin. So that is Article 1482. Let's proceed with Article 1483. Article 1483. Subject to the provisions of the Statute of Frauds and of any other applicable statute, a contract of sale may be made in writing or by word of mouth, or partly in writing and partly by word of mouth, or may be inferred from the contract of the parties. So, Statute of Frauds. Kung gusto nyong i-review yung thorough discussion talaga natin about sa Statute of Frauds, pwede nyong balikan yung discussion sa Oblicon. Yung sa second part ni Article 1403, yung mga unenforceable contracts. Maglalagay na lang din ako ng link dito, just for you to better understand this topic, okay? For validity purposes, yung contract of sale talaga may be entered into in whatever form. Makikita rin naman natin siya kay Article 1483, di ba? Sabi nga it may be made in writing or by word of mouth, or partly in writing and partly by word of mouth, or may be inferred from the conduct of the parties. But then, for enforceability, para maging enforceable yung contract of sale, dapat daw, pag sale of real property, real or immovable property, or any interest therein, sabi, it must be in writing. Otherwise, resale is unenforceable. Okay? Linawin lang natin ha. Yung sale ng real or immovable property, kahit na verbal lang, orally made, okay? It is valid between the parties, kay buyer and kay seller. Pero para maging enforceable, dapat naka-in writing siya. To be binding to other persons, yung mga hindi party ng kontrata nilang dalawa, yung mga strangers sa contract nila. To affect third person, it must appear in a public instrument and it must be recorded in the registry of property. Okay? Yun yung rule in case ng sale of real property. Okay? Now, sa sales of personal or movable property, pag daw yung price is 500 pesos or more, it must be in writing to be enforceable. Okay? Enforceability yung dinidiscuss natin. Now, if yung price ng sale ng personal property or movable property is less than 500 pesos, then oral or verbal contract is enforceable. Pero class, to better understand this, please revisit yung discussion natin kay Article 1403. Okay? Unless nga siguro tingin nyo, no need to revisit Article 1403 kasi masyado pang fresh sa memory nyo yung discussion and you think na na-master nyo na talaga yung topic ng unenforceable contracts, then that's good. Congrats for having a brilliant mind and a very good memory. Anyway, end muna tayo dito. Tinitingnan ko yung kasunod na provision, Article 1484. Medyo mahabang usapan to. The problem with a very long discussion kasi matatagalan mag-edit or gumawa ng presentation. See you again on our next video. If you find this video helpful, please do like, subscribe, and click that notification bell. Salamat!